You're looking for perhaps rolling back, perhaps removing, possibly. What sort of changes would you like to see if hypothetically you were in government or had some kind of leverage over government?
Well, I think the Charter should be expanded to include economic, social and cultural rights. The Brennan report and the consultation which has taken place over last year and this year, which has been the most extensive community consultation in Australian history, found universally that those economic, social and cultural rights were the very rights that people related to and understood should be rights that were protected.
The right to health, the right to housing, the right to education, these sorts of things.
That's right. And most other countries in the world do recognise those rights, and there are some balances there. For example, it's not the courts that determine how we raise and spend a budget, but decisions of courts can affect the budget. I mean, just having a court is a budgetary decision. If you say there's a right to a fair trial, there's a budgetary consequence. And in, for example, South Africa, under its new constitution where these rights are recognised, there's been a number of decisions. And of course, the provision of, for example, housing to people who've got no shelter at all can be very important, and it must be done in accordance with what is reasonable, having regard to budgetary constraints. But not every homeless person can go to a parliament and ask for help. But the courts are well suited to dealing with issues of human rights like that.
Robert Clark, what do you make of the idea of expanding our charter to include the right to housing, the right to education, the right to healthcare?
Look, obviously I'm a lawyer by background. I wouldn't have become a lawyer if I didn't have a passionate commitment to justice and a passionate view that injustice and unfairness should have a remedy. But I'm also of the view that a world run by lawyers is not necessarily going to be a better place. And there are crucial issues involved in decisions relating to the amount of public housing that's provided, the extent to which the police force is funded, how well our public transport system is resourced, that are collective decisions to be made by the community about raising funds and about allocating funds. And to have a court system second-guessing the community's decisions on that is, if anything, likely to be counterproductive. It's certainly going to take decision-making away from the community and vest it in other bodies who are not necessarily well qualified to do it. Certainly if legislation confers a right, if the legislation confers a right to public housing in certain circumstances on certain individuals, then that may well be a justiciable right. But it doesn't seem to me that you need to impose an international covenant or make provisions of an international covenant or even a modified form of an international covenant part of enforceable rights. You're going to end up, you're going to run the risk of ending up with a large number of complaints or demands on the community to deliver resources to particular ends without the community having a say as to how appropriate that is and as to the community's priorities between competing demands on public resources.
So I think what Robert is saying is that we'd have judges poring over policies of health and education and housing, and is there expertise? I mean, the argument could be made that their expertise is not to unpick and unpack these policies. That is better left to the politicians.
No, the way it works, and the way it works overseas isn't that way. But for example, in South Africa there was a case where there were 120 people literally sleeping in the open without any support and the government not taking any steps. Now, one of the dangers in a democracy and one of the reasons we have a Westminster system is that because it's a majoritarian system, there are those who aren't part of the majority. There are minority groups. And the whole point of human rights is not to empower judges, but to empower them. Unelected citizens are the people who get power. And it is not as though the courts can say, well, you've got to give these people housing, but they can assess whether the steps taken have been reasonable within the budgetary constraints that exist. And they can make a declaration, yes they have, or no they haven't, because you haven't done this or you haven't done that. It's not for the courts to make the decision, but it is for them to say whether rights have been violated in the particular circumstances of the case.
I'd like to get your opinion on a recent decision, Victorian court decision here. In July, the Supreme Court held in the case of Castles and the Secretary to the Department of Justice that a female prisoner was entitled under the Charter to continue IVF treatment that she had started before prison. Briefly, I'd like to get your comments both on that decision.
Yes, prison is the deprivation of liberty for just reason. Commission of a crime, in this case I think it was social security from memory.
Yep.
So we deprive someone of their liberty. But do we therefore deprive them, for example, of other rights? Do we deprive them of shelter? No, we assume a responsibility to give them shelter. Do we deprive them of food? No, we assume a responsibility to give them food. Do we deprive them of health care? Of course not. This was a prisoner who was entitled to leave the prison unescorted to receive podiatry care. Why shouldn't she also be able to receive IVF care if that was her choice? The deprivation of liberty is one thing. The deprivation of other rights is separate.
Robert Clark.
Look, I'm not fully familiar with the facts of the case, but I think if you look at it in terms of principle, what it should turn on is the comparability between what the prisoner was claiming in that case and rights or indeed privileges that may be available to prisoners in other circumstances. It seems to me hard to argue in abstract that prisoners automatically have rights to IVF treatment or indeed rights to conjugal visits, but as I understand it, part of the argument in this case was that other prisoners had rights to conjugal visits and therefore had the capacity to conceive children through that means, whereas this particular prisoner didn't. So I'm sorry to give a qualified or a conditional answer, but I think it does very much depend on the facts of the case.
Well, moving on, we're now going to talk about discrimination and equal opportunity exemptions. Earlier this year, the government revised the Equal Opportunity Act, removing some exemptions and leaving some exemptions in place and amending the scope of yet others. I'd like to ask you both, are exemptions to non-discrimination laws desirable? They are, of course, effectively permission for certain organisations to discriminate. Brian Walters.
See, on the one hand, we have the value of equality. A fair go, and as a matter of principle, that's a good thing. And we also know that equality is important for a productive society, for a prosperous society, for people to feel free within a society. And so it has a positive benefit as well as a principal benefit. On the other hand, we have other human rights. So the right to freedom of religion is a right that we should value and uphold because there are different religious points of view, and in a society such as ours, we like to give people as much freedom of expression in their religious sphere of life as we can. But does one right always trump another? Does freedom of religion always trump equality? Because if it does, we've got a problem. Now, currently with these carve-outs, that's what happens. Whereas I think it ought to be a matter where you consider each case on its merits. I mean, is it appropriate to permit a religious institution to refuse to employ a cleaner because they are gay? Now, let's have a look at how central this belief is to the religion. Let's look at the rights of the individual. Let's not make it a blanket exception. I mean, I have a personal view about that, but the process ought to be not